Plus Rick. Plus. I like it sign with you.
All right. 7 o'clock, we'll call this meeting to order. Roll call. Andy Rocket is absent. Susan Peck.
Here.
Ralph Williams. Yep. E.J. Farrell. Dan Thayer. Here. Doug Stebbins. Here. Dean Hills is present.
Bernard, I'm sorry you didn't mention.
What's that?
You didn't mention Joe.
Oh, yeah, Joe Marinaccio is not present. For the purposes of tonight's meeting, two regular members are not here, so I'll appoint Ralph and Susan as the voting members tonight. They are alternates. I'll read the legal notice into the record. GBA 23-005, 120 Watchog Road LLC, 120 Watchog Road Summers. Appeal of zoning enforcement officer's denial of application to construct a 76-foot by 120-foot, approximately 9,000 square foot utility building, replacing an approximately 3,500 square foot demolished building. Yep.
No, it's not yet. Shoot it. No, you gotta just push it once. Don't hold it.
Oh, don't. Okay.
There's a little green light.
Long green light's on, you're on.
Okay. So would the applicant like to come forward, please, for their presentation, and did they provide proof of notification of abutters?
Yes, they did.
Okay, let the record reflect that.
You tell me, you told me before, 6:30.
Does that work?
It's on. It's on.
Okay, can you hear me okay?
Did you turn it off?
Maybe I did.
How's that?
No, you gotta push it and like hold it for a second.
How's that? Good? Good evening, everyone.
Hey, we can't hear you back here.
You have to hold it kind of close to you.
Better?
Up. I'm a little deaf.
Can you hear him now?
It's on. You have to just kind of hold it closer. I don't know.
I will do my best, but if you cannot hear me, please let me know, and we'll go from there. My name is Derek Donnelly. I'm here with the applicant, Owen Jarmock of 120 Watchog Road, LLC. I have some documents to hand out to everyone, which I'd like to do first, and then we can, as we go through our presentation, you can refer to the documents, if that's all right. May I approach?
You may.
So the two packets that I provided you are the presentation that we'll be walking through, and then the exhibits that we're submitting in addition to the presentation. The presentation is set up to refer to those exhibits, and those exhibits are numbered. I would just sort of suggest that, if at all possible, as we refer to the exhibits, you can move through the exhibit packet and look at them.
Please be quiet. Can you, we can get the
Can't hear you.
Volume on that, I mean, I can try and jump in one of the other ones to maybe work better. If the cord reaches, we could use that.
All right.
Test.
Usually it works well.
Are we good with this one? Everybody out there?
You want us to move the table?
Yeah, if you could, that'd be great.
Sorry.
It's on.
Yeah, I got it. Okay.
Turn the green light on.
Thank you. I don't know if this will pick up some...
Yeah.
Okay, how's that? Better for everyone in the audience? Okay.
Come on.
Very good. So what we provided you, as I was saying before, is a copy of our presentation as well as exhibits that the presentation refers to. So ideally, you would thumb through both at the same time and refer back and forth as we go through the presentation. So, again, my name, for the record, is Derek Donnelly from the firm of Blackburn and Donnelly. I'm here with Owen Jarmock, who's the principal of 120 Watchog Road, LLC, who's the owner of the property. So, thank you all for having us here tonight. I served on ZBAs for a long time myself, second generation, I might add. My father was the ZBA chairman before I got on in Suffield, Connecticut, and appreciate everything you have to go through. I've been in your shoes before, and I appreciate that these are not always easy decisions. So if you look through our presentation, the second page, you see present for the applicant, Owen, myself, and also Dwight Merriam. Attorney Dwight Merriam is here with us as well. So just wanted to start by going through a little bit of history of the airstrip here and also the proposed replacement hangar. So Jarmock Farms through 120 Watchog Road, LLC, own a private property located along Watchog Road in Somers, which contains a runway for small private planes and related accessory structures. Okay. Property consists of two parcels. It's 118 Watchog Road and 120 Watchog Road, and we provided you as exhibit.
Yeah, I was wondering, I can't hear a damn thing. I wonder what that was. You can't hear what the hell's going on.
Watch your language.
So we've also submitted the property cards that correspond with those parcels. Okay. In 1972, the former owners of the property, which was the LaChance Potato Company, were permitted by this board to construct a runway and also a hangar at the property. Okay. They were granted a variance on December 12th, 1972, and you'll see in your packet exhibits 3, 4, and 5, which was the appeal, the hearing transcript, and also the notice of the ZBA's decision.
Jen, excuse me. No. Okay.
So,
Well, you can't look at her stuff.
I'm reading it off here because you guys are.
All right, you're gonna have to push back a little bit, please.
What the hell's the sense of gas coming in here? I can't understand what you, I flew for years out of that airport down on the farm. People sometimes are trying to get something in there and you want sneak it in.
Okay, well, you'll get your turn to speak. You need to move away, you need to get...
I'm mumbling, but
I'm
I'm
not
not,
mumbling, sir.
it's for everybody, not just if right here. I have a little hard time hearing, but
Me too.
I don't hear much of anything here.
Okay?
You haven't.
You gotta give her some space.
I put them right over there.
I think that will help him, and he can read his own copy as opposed to read mine. That would help.
Yeah, and I should have mentioned that before, but I did put a couple of extra copies on the chair there in case anyone in the public was looking for them.
Complete set.
Huh?
A complete set of materials.
Okay.
Okay?
All right, thank you.
If you need anything, wave over at me, all right?
Right.
Yeah.
So the variance which was approved by the ZBA provided for the LaChance Potato Company to erect adjacent to the runway a T-hanger for the storage, maintenance, and repair of 2 planes, okay? And we've got, as Exhibit 6, a copy of the variance again. So public notice that the ZBA had granted the variance was published in the Springfield Daily News on December 16th, 1972, and the variance was subject to a 15-day waiting period before the project could be started. There's no evidence in any of the town's files, any records that we could find, that the variance was challenged at any point after that, okay? So it's been in effect since 1972. If you go on to the next page, you'll see that, you know, if you, judging by the 15 days, we're looking at December of 1972, early January 1973. However, the variance was never filed in the Summers land records after it was granted, okay? And that's an important point we'll come back to later on. It was not required by the law at that time in 1972, as it is now. But we'll come back to that in a little bit. LaChance then constructed a hangar that was 70 by 50 feet at the property, and as well as a runway sufficient to allow small aircrafts to take off and land, and that runway's essentially been there since 1972. Okay. Runway's history is very well documented by the town, and I apologize, but Exhibit 8's an aerial view of the property in case you aren't familiar with it. But again, the runway has been very well documented by the town. If you look at the building records for the file, as recently as 2000, Town Attorney Carl Andolina provided an opinion about the runway, okay? And Exhibit 9 is the Landolina opinion, and also a statement of compliance by then CEO Jim Taylor. Importantly, the Landolina opinion expressed that the runway variance ran with the land unless the owner abandoned the use. Later in 2016, there was another request, actually from a potential buyer of an adjacent property, and again, there's a letter saying that the parcels were in compliance in the building file. It references, I note that it does reference the neighboring property, but it's in the building file for this property saying it's in compliance. So we provided that for you again. So in total, those are Exhibits 9, 10, and 11. In October of 2022, Jarmox Farms, through 120 Watchog Road LLC, purchased the property and actually obtained an affidavit from the prior owner of the property, Mr. Mosier, that they never intended to abandon the use of the runway. And that affidavit's in your file as well, and that's Exhibit 13. So the runway itself has been continually licensed by the Connecticut Airport Authority, and it's noted on all FAA records as an active airport, as it has to be, pursuant to FAA regulations. And we've provided you copies of the CAA certification, as well as the FAA information, and that's Exhibits 14 and 15, okay? And I will just sort of stop there and say, I know that we're providing you with a lot of information and a lot of exhibits, but there is a lot of information available, and we thought it was very important that you have everything. And as we go through this, if something pops up and you have a question, feel free to interrupt me and I can address them as they come up. The one thing to note, though, is that when the Jarmucks did take possession of the property, the runway was in poor repair, okay, and needed repair immediately. And one of the things that Mosier says or implies in his affidavit is that while they never intended to abandon the use, they also couldn't keep up the repair of the runway. So that was important. A few days after buying the property, Watchog Road LLC applied for and received a driveway permit from the town, allowing them to repave the runway, okay? So you'll see Exhibit 16, which is the permit, the driveway permit, as well as Exhibit 17, which are the paving invoices. And I'll note, the paving of the runway came at great expense. So it's pretty significant. If you've ever had your driveway paved, you know how significant that cost can be even for a small driveway. If you multiply that by a runway, you'll see it's fairly significant. So in the hundreds of thousands of dollars range. So again, I mentioned before that there were two parcels, 120 and 118. The hangar itself is on 118 Watchog Road, and the Jarmucks took possession of that neighboring property in January of 2023. Okay? So, although these parcels were once one parcel, okay, they were split up by the previous owner, and you had the hangar on 118 and the runway at 120. So just want to be clear. So you'll see throughout that we mentioned both of them. They're owned by the same LLC. So as part of this, eventually we do have surveys that have been done to try to merge the properties together back to where they were before at one point. So in addition to the repair of the runway, the town also took a couple of other actions after it was done. A couple of planes landed, and the Board of Selectmen decided in February of 2023 to put new signage on the road stating that low-flying aircraft were nearby. So if you've driven on Watchog Road, I'm sure you've seen those signs. Okay. And you'll see Exhibit 18, which is the Summers Board of Selectmen minutes from February 16th of 2023. So Jarmuck Farms has since demolished the hangar with the intent to rebuild it, okay, and has submitted the requisite applications to the town, including a zoning application with a full plot plan, and you'll see Exhibit 19 and 20, which are the zoning applications and the plot plan. We also have a blown-up version of the plot plan for you to refer to if you'd like as well. So, and that's what you see in front of you on the floor. So if you go on to the next page, but before we get into the denial itself, in addition to the history, we just wanted to provide a little bit additional context, okay? First about the denial, which we'll go through, and then a little bit information about Jarmuck Farms, who owns the property, again, through 120 Watchog Road, LLC. So what we've done is like the LaChance Potato Company, when they originally applied for the variance, they were looking for a variance to allow them to store 2 small business planes, okay? And that's precisely what we're looking for here. So it's a hangar to store 2 small business planes. The use of the strip per the variance is business related, period. So there's no recreational activity here, there's no training, there's no recreational flying. These are flights for business purposes. Okay, we provided you with a statement of need about the hangar, which is Exhibit 23, that goes into a little more detail there for you to review. Obviously, the question that your zoning enforcement officer naturally had was, well, why a bigger hangar, right? And the reason for that is a number of things have changed since you could get 2 small planes in 1972. FAA defined small planes as bigger than what they were defined in 1972. There are OSHA requirements that specifically require certain things to be present in an airplane hangar. You have to store the fuel in a certain manner. You have to have storage facilities that are secure. And very importantly, you have to have the safety requirements such as eye washing and restroom wash-up activities, things like that. So a lot of it has changed. And we've also provided, as Exhibit 24 and 25, the floor plan of the facility as well, which, where's that one? Oh, right over here. So, yes, we've got a blown-up version of that as well. And with that, I'll just turn it over to Owen to give a little more information about the farm and the activities.
Okay, thank you. For the record, my name's Owen Jarmock. I am the 4th generation. Jarmock Farm is my father's actually here too. He'd be the 3rd. And so my family's farm started in 1907 with my great-grandfather Stanley in 20 acres on a farm in Enfield. And since then, we've shown, a willingness to grow by empowering the latest technologies. And there's been a lot that we've really worked on. And so we actually own the property across the street too, and we believe that agriculture makes up an important fabric of the town of Somers, and we're really committed to preserving that and continuing to grow here. But so our business is a little different from LaChance with potatoes. We grow mostly cigar binder tobacco. And so this is saying our business requires an effort driven by world markets and technology changes. Instead of going to Maine to his potato farms, we have business partners, suppliers, most of our customers, and really an important fact is our labor force is located roughly 2,000 miles away. In the summer months, we house over 200 employees from Jamaica and other countries in Central America. And so there's a need for us to go farther and faster than was necessary 50 years ago, sometime and most of the time on short notice in order to compete in world markets. We don't need to go through all of this. So we're really here tonight, as an opportunity to work together to make it clear what was approved, 50 years ago and maybe answer some questions. And so we're just asking that you please help keep our business strong as it can be by recognizing that the hangar is consistent with the original variance and it's permitted to meet changes in business needs and be responsive to advances in technology and new requirements with the law.
So the town denied the zoning permit on May 25th, and Exhibit 22 and 23 is the original denial, which was May 25th, and on May 31st, the zoning enforcement officer actually provided us a much more detailed explanation, which was much appreciated. So we're really here to discuss that denial, and that denial was focused on 5 reasons. Okay. Number 1, that aircraft-related buildings were not permitted in the A1 zone. Number 2, that the variance that allowed a private landing strip and hangar was never filed on the land records, and the current use is therefore non-conforming. Number 3, assuming that the current use is non-conforming, the proposed hangar would be an unlawful expansion of that use. That the prior variance was personal and did not run with the land, and that the previous owner conceded that the variance was personal when it was granted. So, as a result of that, we did some research. We looked around, and we sought the opinion of Judge Marshall Berger, former Judge Marshall Berger, who ran the land use docket in Hartford for a long time, because these really are some complicated issues. And what we have for you as Exhibit 27 is the opinion from Judge Berger that rebuts, point by point, these 5 different reasons for the denial, okay? And we've provided that to you as well. if it's all right with you, I'd just like to read this into the record because I think it's important to have it there. The rest of the exhibits are there for your review, but I would like to put this into the record if that's all right, and I will do that as swiftly as possible.
Please go ahead.
Thank you. It's addressed to Attorney Merriam. Dear Attorney Merriam, pursuant to your request, I reviewed Jennifer Roy's May 31st, 2023 explanation of her May 25th, 2023 denial of 120 Watchog Road LLC's application for a zoning permit and for the replacement of the hangar at 120 Watchog Road, Somers, Connecticut. Ms. Roy offers 5 reasons for the denial. I've just covered those. I won't repeat them again. My comments are as follows. Reason number 1. I start with the December 12th, 1972 variance to a predecessor in interest, LaChance Potato Company. The provided legal notice states, in conformity with the state law, the Somers Zoning Board of Appeals has this day filed with the town clerk notice of granting an appeal of the LaChance Potato Company for variance and approval of the installation of a private and restricted north-south minimum length 2,500-foot runway on company property south of Watchog Road in Somers. This runway is for the takeoff and landing of the company's 2 small private planes used strictly for company business. Permission was also granted by the board to erect, adjacent to the runway, a T-hangar for the storage, maintenance, and repair of these same planes. In granting this appeal, the board wants to make it quite clear that this proposed operation in its entirety will be subject to all local, state, and federal rules, controls, and regulations that apply to the above situation and description. Judge Berger goes on, I have not been provided with anything to suggest that the variance decision was challenged, other than one neighbor concerned about a negative impact on his property and some comments about noise. The transcript shows that most members spoke in favor of the variance. Indeed, the note on the board's minutes, which indicates the decision was unanimous, states that, quote, there was very little opposition shown. There were about 40 people in attendance. Hence, pursuant to the board's decision, LaChance Potato Company erected a 70 by 50 hangar for 2 aircraft. It is noted that the above variance does not have a stated size for the hangar. It's also noted that 120 Watchog Road's current application seeks to replace the current structure with a 76 by 105 structure. In terms of the reason for the denial, that the current zoning regulations exclude aircraft-related structures and buildings in that A1 zone, Ms. Roy is correct. Section 1.4A1 states any use not specifically identified in these regulations as permitted in the zoning district by zoning permit, by site plan, by special use permit, or allowed without a permit shall be deemed to be prohibited within such district. Evidently, that was true in 1972, and that is the reason for the variance, which precisely allows that which would ordinarily be precluded. The variance, quote, a variance is authority extended to the owner to use his property in a manner forbidden by zoning enactment. And Judge Berger cites the case of Town of Burlington versus Jensic. Ms. Roy's first reason would be correct if there was no variance. It is incorrect because LaChance Potato Company was granted a variance. Reason number 2. Ms. Roy next opines that she has found, quote, no indication that the variance was ever filed on the land records as required by state law, end quote, and thus the landing strip and hangar were not constructed legally and cannot be considered lawfully non-conforming uses. Ms. Roy refers to 1977 Public Act 509, which was not in effect in 1972 when the variance was granted. As stated in the case Cronenberg versus Zoning Board of Appeals, and the citation is there for you, a case with a similar situation, quote, the first reason for the board's decision is that the use variance has not been recorded on the New Haven land records pursuant to Connecticut General Statutes 8-7. The provision, however, was not enacted until 1977, 11 years after the variance was granted. Prior to this enactment, a variance became effective, quote, at such time as is fixed by the board. Accordingly, the second reason would not be valid. Reason number 3. The third reason assumes that the prior hangar is a lawful non-conforming use, but due to the increase in size would constitute an illegal expansion or extension of that use. Quote, the legality of an extension of a non-conforming use is essentially a question of fact. We have previously held that a mere increase in the amount of business done pursuant to a non-conforming use is not an illegal expansion of the original use. A change in the character of the use, however, does constitute such an unlawful expansion of a prior use. And Judge Berger cites the Helicopter Associates versus City of Stamford with the citation there as well. The court therein ruled that the applicant's desire to have an unlimited number of flights over the current 36 flights per year constituted an unlawful expansion of its legal non-conforming use. Further, it noted that such an increase would constitute a change in character of the existing use in violation of the town's zoning law, and thus not unlike the change in character in those alcohol-related cases where an applicant sought to expand its sales simply from beer to all types of alcohol. After the court decided Helicopter Associates, it addressed the expansion intensification issue in a case where the applicant sought to add additional antenna to an existing non-conforming tower and install a generator and fuel tank. The court held that, quote, none of the evidence presented to the board would justify a conclusion that the character of the non-conforming use of the tower and pertinent equipment had changed, despite the increase since 1957 in the number of users from 3 to 11 and the related addition of more equipment having the same purpose as that originally installed. And that case is that he cites is Zachs versus Zoning Board of Appeals with the citation there. The court stated, quote, in deciding whether the current activity is within the scope of the non-conforming use, consideration should be given to three factors. One, the extent to which the current use reflects the nature and purpose of the original use. Two, any differences in the character, nature, and kind of use involved. And three, any substantial difference in the effect upon the neighborhood resulting from differences in activities conducted on the property. Jarmock's new hangar, while larger than the prior structure, certainly comports with the Zachs threefold test. It reflects both the nature and purpose of the original hangar. Indeed, a review of the original variance transcript reveals that the planes were used for the LaChance's commuting purposes to Maine and other facilities. This is exactly the same type of use that the current proposal contains, although admittedly the applicant's current business requires flights to places beyond Maine. Its footprint is larger, but that does not contradict its nature and purpose. The prior hangar housed 2 planes. The current proposal is for 2 planes. Jarmock proposes to house a single-engine Pilatus PC-12 and a twin-engine King Air 260 planes, which did not exist in 1972, but which are updates of those housed in the earlier hangar. Importantly, there were no building dimensions specified in the variance. And he cites, quote, permission was also granted by the board to erect, adjacent to the runway, a T hangar for the storage, maintenance, and repair of the planes, end quote. So regardless of whether the specific size was a concern for the board at the time, the actual as-built size was 70 by 50 feet. The hangar is designed for the same use as a prior building to house 2 planes. The wingspan dimensions of the planes in the new proposal is 53.18 feet. The prior plane was believed to be 37.10. Planes have increased in size, and the door required would be 65 feet, allowing just a minimal but necessary 5-foot clearance on both sides. Similarly, the length of the new plane is 47.25 feet. The prior plane was believed to be about 29.10 feet. With one plane in front of the other, the planes would need 94.50 feet, plus some minimal clearance between them and some minimal distance between back and front. The new building will include 2 20 by 12 storage units required for the safety of the employees and the maintenance of 2 planes. OSHA has mandated certain safety facilities, and they do not require additional space. They do require additional space. Thank you. Section 1910.151C states that, quote, where the eyes or body of a person may be exposed to injurious corrosive materials, suitable facilities for quick drenching or flushing of the eyes and body shall be provided within the work area for immediate emergency use, end quote. The proposal meets the requirements by including a shower washdown, an eye wash for the health and safety of employees, Section 1926.152G concerning service and refueling area states at G1 that flammable liquids shall be stored in approved closed containers and tanks loaded underground or in above-ground portable tanks. Again, the proposal has designated one of the storage facilities for the fireproof storage of flammables, lubricants, and other materials. These additions are essentially no different than the additional generator and fuel tank required for the tower in Zax. While they add to the increased dimension of the proposed building, they do not change the use of the non-conforming structure. The proposed structure is larger at 76 by 105 feet, but is the same nature, purpose, and character of the previous structure. Finally, it cannot reasonably be argued that the proposal violates the third Zax test of having a substantial impact on the neighborhood. There is evidently community support for the proposal. Our Supreme Court has stated that the fact that the improved and more efficient instrumentalities are utilized in the pursuit of use does not exclude it from a category of existing use, provided these are ordinarily and reasonably adapted to make that use available to the owner, and the original nature and purpose of the undertaking remain unchanged. He cites to De Felice versus Zoning Board of Appeals. Such is the situation with this somewhat larger building. And then as to reasons 4 and 5, Ms. Roy states that her fourth reason for the variance was that it was personal and did not run with the land. Such a reason is related to her fifth reason, in which she maintains that the attorney for LaChance Potato Company conceded that the variance was personal by stating, quote, "It is a landing strip just for the LaChance Corporation, the Potato Corporation. We would be willing, in the event the board saw fit, to install the strip for the placing of any restrictions which the board felt would be in the public interest," end quote. First, such a comment is indistinguishable from any request or summation of an applicant seeking a permit from a municipal land use board. Quote, "If you grant our permit, we would be willing to abide by any restrictions," end quote. More importantly, however, quote, "Zoning is concerned with the use of property, not primarily with its ownership," and he cites to Verillo versus Zoning Board of Appeals. The legislature amended Section 8-6 in Public Act 93-385 to add, quote, "Any variance granted by a zoning board of appeals shall run with the land and shall not be personal in nature to the person who applied for and received the variance. A variance shall not be extinguished solely because of the transfer of title to the property or the invalidity of any condition attached to the variance that would affect the transfer of property from the person who initially applied for and received the variance," end quote. This is a statutory pronouncement of the Connecticut land use case law, which recognizes that variants are not personal. And he cites to Gribaldi versus Zoning Board of Appeals. By its very definition, a variance is granted with respect to a particular piece of property that can be enjoyed not only by the present owner, but by all subsequent owners. It follows then that a variance is not a personal exemption from the enforcement of zoning regulations. It is a legal status granted to a certain parcel of realty without regard to ownership. Hence, he concludes, these two connected reasons are also invalid. Accordingly, it is my opinion that the proposed structure, while certainly larger, does not violate our case law and constitute an unlawful extension of the non-conforming use and structure. I thus disagree with Ms. Roy's reasoning in her denial. So, there's a couple of other considerations that I'd also like to bring to your attention before I conclude. As referenced in Judge Berger's letter, the hangar size was never defined during the hearing process. Although it is noted in Ms. Roy's letter, and it's important to point out to the board, that in the application there was a drawing that shows what seems to show a 70 by 40 accessory building. Very importantly, we've also submitted the as Exhibit 29, the assessor's card showing that that property had been assessed for a 70 by 50 building, and indeed the LaChance Company built a 70 by 50 building. So to the extent that there was any consideration to the size of the building, the size on that original application never came to fruition. They already built a bigger building. And the size was essentially never discussed with specificity during the public hearing process. And I note, without getting into too much more detail, because I've beleaguered you enough tonight, but that there was no enforcement action ever taken by the town against the larger building, right, which had existed for 50 years. Also important to note is that there has been, and the reason we pointed all of these out at the beginning, my client has relied on the previous approvals by the town with respect to this property. So as for instance, the paving of the runway at great expense was approved by the town. And very clearly that it was going to be a runway, not a driveway or anything like that. So there is, a significant amount of case law regarding municipal estoppel, and the premise there is that if the town grants you authority to do something, the town can't then change its mind. And the implication in the letter, the denial letter, while specific to the hangar question, also seems to imply that the runway is not an approved use. And I think we rebut that within the context of Judge Berger's decision. So at the end of our presentation, I did provide you with a proposed motion, just something to consider. I always find when I'm on a board, it's a little easier if you have something to look at. And obviously, we welcome questions from the board, welcome questions from the public. In addition to the materials we presented tonight, over the course of the last week or so, we've also presented a number of letters of support to the zoning enforcement officer for the approval of this hangar. So, with that, I think we'll open it up to any questions.
Any questions, board members?
One question I have is I'd like to know where the records were found if they weren't on the land records. I mean, you clearly found the records of the 1972 proceedings.
Yes, I give your building department a lot of credit. They were right in the building department's files. I can tell you that I have served as town attorney for many towns. You do a miraculous job here of keeping old records. So they were all right in the file, easily accessible with Jennifer's help.
The accessibility impresses me even more than the keeping.
I have a question.
Go ahead, Susan.
So, the piece of property, I've been trying to understand, so over the course of time, you've bought the piece of property and kind of, you're putting them together. So, I noticed when I drove by the house that is on this piece of property, my question is it going to be torn down?
I don't know if we're going to keep it now.
Yeah, at this point, it's unclear if it's going to be rehabbed or torn down, but it has to be addressed at some point.
The house is in disrepair, there's no one currently living in there.
Correct, there's no windows.
No,
right? Yeah.
it's
Right.
in
Well, not no
complete
windows,
disrepair.
but, yes, okay. So my question with that is, what is this going to be an accessory building to on a residential zone?
Yeah, so it was approved then as an accessory, essentially accessory building to the runway, is how the variance was granted. And I realize that does not fit into the typical definition of an accessory building. But, the thought has been consistently to rehab that building and merge the parcels. I will tell you that has not happened yet in the short amount of time that they've owned the property, which hasn't even been a year yet.
Okay.
Yeah, I don't want.
It's a good question, because it does raise this, accessory typically is accessory to a residential.
Well, that's what I was wondering, in 1972, was it an accessory building to a house?
Yeah, I just don't want to get too far off topic, because we're basically concerned with the proposed building. because we're not really dealing with the accessory stuff, it's strictly the building.
But it is an accessory building.
Correct, but that's not what we're here, the appeal is over the granting of the permit for the hangar. So we really want
It
to kind of
is.
stick on topic for that.
But that's the accessory building, Dean.
I understand, but
Okay.
that's not what the appeal is about.
To make the accessory building larger. Well, I'm just wondering what it would be an accessory building to. I'm sure that was a question Jen had too. Like, okay, my next question is, I see different things on here. I see that the new building will be 76 by 105, and then in another place, I see the new building's gonna be 76 by 120.
Yeah, so the original, request was for a 76 by 120 building. The updated plans were for a 76 by 105 building. Part of the, understanding that we get from Judge Berger's opinion is that really we can't expand this beyond what's needed for 2 planes.
Okay.
So once the study was done about fitting in the 2 planes, plus the required OSHA, facilities, the size of the hangar was reduced to the 76 by 105.
Okay. And
And thank you for pointing that out. I meant to mention that at the beginning, and I got kicked for that, under the table.
Okay, so at this point it's 76 by 105. Okay. And just another question about the building. Are there gonna be people employed full-time in this building?
No.
Okay.
It's really just a building to store 2 planes.
Well, it said employees and,
The Department of Labor is very broad when they define employee. If it's a business plane and whoever's flying it, whether it be my father or myself or one of our contract pilots, even though I'm not technically an employee of the company, you still have to have the reasonable accommodations that any employee would be afforded.
okay. Okay.
May not be pertinent, but do the OSHA requirements also require that the building for housing aircraft have fire suppression capabilities, and will this have it?
This bill, it does, NFPA does require it, but this building's under the footprint which it is required. I believe it's 12,000 square feet or above. They required a special fire suppression foam system for aircraft.
Any further questions from the board?
Not at this moment.
This building would be obviously be larger than the previous hangar. Would it be in roughly the same location?
Exact same, yep.
Anybody else? I'd like to get the feel of the board. I know myself we're having a lot of information thrown at us tonight, so I would like to continue this hearing and keep the public hearing open until the next meeting, because I want to be able to review all this stuff and come back and, you know, be much more well-informed than I am tonight. So, is it the board good with that?
Do you wanna listen to the public
Oh,
tonight?
absolutely, yeah, we're gonna keep going.
Okay.
I just
Oh,
want
okay.
to,
Yeah.
be clear on that, so
Okay.
that, because I may have questions, but I'm probably not gonna be asking them tonight.
Right.
So
Okay.
If there's no other questions from the board, does the public have any questions for the applicant,
Would you like us to move so the public can come up?
No. Any questions from the public, comments?
One question, Mr. Chairman. Should we hear from the zoning enforcement officer, first?
I think just if they have any questions for the applicant, then if they have questions for Jen, we can do that too. John?
Comments, I don't know.
Yeah, no, yep.
Can I approach?
Mm-hmm.
Yeah, we need the microphone.
Yeah.
There's a little mess here, but I promise we'll clean it up after.
Okay.
That's what all the kids say. That's what my kids say.
Good evening. My name is John Parks. I'm a resident of Summers. My brother lives on Candlewood Drive. I'm an attorney in Summers. A number of the neighbors have asked me to come tonight to listen to what's going on across the street from them. I've listened to what was a very thorough presentation couple, points that were omitted, and then, I'd like to comment on, Judge Berger's, letter and a few other things that were presented. So, I'm a lifelong resident of Summers. When my family grew up in Summers, Tom LaChance was, a big fish in a small pond. Everybody knew him and, also knew what he was, doing. And I wasn't at the meeting in 1972. I was a senior in high school at the time, but I'm well aware from that point to now, the history of the airstrip, including snowmobiling down there, riding dirt bikes down there, and what really is going on with this building and the application is a step in a process that is not only an illegal expansion of a use, but an illegal expansion of structures. And the template that you have laid out in front of you in the 1972 transcript, which was super that they still had that, really demonstrates well the expansion of this use. And let's start with the plane, because Tom LaChance was very specific on page 16 of the transcript. I have a single engine with a gross weight of 2,600 pounds. This plane, per that exhibit, is 12,000 pounds. It's a 9-passenger plane. It's got a pressurized cannon, cabin, no cannons, and it's about as like what Tom LaChance flew as night from day. This travels, so it's like 4 times heavier, at least 2 times bigger. It travels 3 or 4 times faster, and the way we know that is on page 13. Tom LaChance tells us that his plane goes 120 miles an hour. To cruise at the altitudes that plane travels, and I actually have some information about that plane, but unfortunately, my information was that it was a smaller plane, but it's, and as soon as I find it, I'll give it to the board. May I present, or, so the plane that I have information on is the right brand, Pilotus. I got the PC-12, which is apparently half the plane that is depicted there, but this one goes 311 miles an hour. It has a turbo something or other, which is clearly light years ahead of where Tom LaChance was with his little puddle jumper, but I would like to, who would I give that?
I have a question. Tommy has a twin engine.
He also had a twin-engine plane, and that plane was 4,000 pounds, so a quarter of what this is. This is, it's not a jet, but, yeah, turbo, exactly. So you have your template of what was supposed to happen. Like, for example, the runway was supposed to be 40 feet wide. That's on page 2 and page 3, it looks like that's a 3, or maybe it's a 5. The runway is a lot wider than 40 feet wide. The important distinction between 1972 and now is in 1972, Tom LaChance owned everything around there, hundreds of acres. In fact, his attorney threatens the opposers that he could put 200 or 300 cattle there if they wanted to complain about his airport. So this much bigger, much faster aircraft is got to land on a very narrow piece of land. Quite frankly, I don't know how this ever got split out. There was no subdivision of this land approved by any board, but when the farm was lost to production credit, it got parceled up. And this is the oddest looking parcel. I'm going to put this in. But you see the landing strip. Well, this was all part of the land that was applied for an airstrip on. And now we've got this thing so narrow and the hangar on another piece, and we're trying to put 4 times the air power on it. It's an expansion of a use, so you got a much bigger planes, much more intense use on a very much smaller parcel than was before this board in 1972.
Who would I? That's from the
Town assessor. So, you know, I looked at everything, I listened. What this board has to hang its hat on in supporting the decision of the zoning enforcement's decision is this is an illegal expansion of a non-conforming use. So, all you have to do is read this transcript. That was what's supposed to be in there, not 4 times what this is, because their business model has changed. So rather than flying to Maine, they're flying to Puerto Rico or wherever they're flying. That's not the neighbor's problem. I mean, this is going to be a business operated, and it was stated business, this is a residential zone. What's to stop this applicant from chartering flights to Martha's Vineyard and Nantucket?
That's irrelevant, John. Irrelevant in this particular case.
Okay, I take it.
Rules and regulations.
Okay. So, good point. So the issue is, what zone are we in? What was the scope of the original variance and what is being applied for? And if you compare the original scope per the transcript to what we're being asked to swallow here, it's clearly an illegal expansion of a non-conforming use. Thank you.
Can I ask you a question, John? What did the neighbors say?
Well, so here's what's going on down there. So the applicant is...
May I just interject for one moment? If Attorney Parks is representing specific people, we should probably know who those are, rather than just a general, this is who the neighbors are. He mentioned his, like your brother?
Yes.
Yeah, so, you know, if you have clients that you're representing, that's fine. Otherwise, I mean, it's not relevant unless they're here to speak.
I agree.
Yep, okay. Yep.
I'm not sure.
Do you have clients that you're representing?
Yes.
Before the board?
Yes, I do.
And you state those for the record, please?
Yes. My brother Michael Parks, his wife Maureen Parks, their children Nate and Trevor Parks live on Candlewood Drive.
Okay, very good.
And his neighbors, the Russells, have also asked about this and want to be involved. To be honest with you, everybody on that street is concerned because they witnessed a plane coming down to the runway and doing barrel rolls over the runway and then taking off, you know, since the place has been paved. It did not touch down, but there's, I'll say this, the scope of what's being proposed there is greatly different than the
Okay,
scope.
I agree with that, you know, that you're okay to, include some of this other stuff as, you know, a part of increasing the scope toward the building. But let's, kind of keep it on topic.
Okay.
Okay?
I don't know if I answered your
You're
question.
good. You're good.
Any other questions? Thank you.
You're welcome. Go ahead, Dan.
Dan Thayer. A question for the Jarmac attorney. Has this landing field ever fallen out of use completely?
I'm coming up for the microphone. So there were periods of time where the runway was not in use, but it was always identified as a runway.
By whom?
By the FAA.
Okay.
And the CAA, the Connecticut Airport Authority. So the runway did fall into disrepair during as we stated earlier, during the prior owner's ownership of it, and as a result did not have active planes taking off and landing. But one of the things that we provided you is his affidavit saying that he never intended to abandon the use. He never gave it up. And that's really what the standard is from a legal perspective, is you cannot use a variance, but until you intend to abandon it, it doesn't go away.
There were or were not helicopters flying in and out of there?
Not since my clients own the property.
Maybe back.
Not since then, yeah, okay.
Yeah.
I know in 2000, maybe 10 or 8, Kenny Jakowski was trying to spray with helicopters, but to be extremely clear,
There was one hangar there, he had it on a trolley, so.
Yeah, we're not aware of that, and
Okay.
and certainly we dispute any barrel rolls that may have been seen. That is not something that happened. These are, you know, there's only been business flights there, so.
Is the size of the airplanes that can use that runway stated, or is it simply a matter of the physical size of the runway and what it can accommodate that can safely take off and land?
Both those two planes on their specs, they can safely take off and land on that runway. I think that's probably one of the reasons why we've chosen to, purchase a Pilatus, is because they're one of the only planes, single engine, that can get us where we need to go. And they're designed not only to land on asphalt, but they're rated to land on grass, gravel, unimproved areas where we're traveling. And, we have a lot of customers and different farmers that we work with in Nicaragua, Honduras, San Andreas, Mexico, where there's not exactly a commercial flight to get there.
And with respect to the original variance, yes, it approved a specific size of the runway.
Has that changed?
No.
You simply repaved the same existing size?
We hired Garrity Reclaiming and Asphalt Services, and they came in last fall, and they essentially, Tommy LaChance did a great job in constructing it. The base was unbelievable, and so they essentially just reclaimed. They had a big machine that crushed up all the old asphalt. They regraded and paved over the top of it. So what was replaced was exactly...
So it wasn't made wider, it wasn't made longer?
No, we reclaimed exactly what was in place.
Can we stick, because we're really here for the building, so if we kind of move on, the runway really doesn't, I it's part of the project, but the appeal is for the building, so can we...
And if I could just address what was just presented, in a roundabout way, Attorney Parks actually makes the point that's set forth in Judge Berger's letter, all right? It's not an expansion if you have improvements in technology that lend it to the same thing. What was discussed at that hearing was 2 business planes, a single prop, and a double prop plane, which is exactly what we're talking about here. Yes. Are they bigger? Yes. Do they travel farther? Sure. But they can land on the same runway, and the expansion of the hangar is to store 2 business planes used for business purposes, which was what was granted to Mr. LaChance in 1972.
Go ahead.
So, the turboprops?
It's my understanding, yeah, that's.
Yeah.
Both of those are turboprops. The Pilatus is a single-engine turboprop. The King Air is a relatively larger dual-engine turboprop.
So you have to reverse the, or break
The props
Yeah.
do have capability of reversing, yes. Or reversing thrust, let's put it that way.
Right.
And I think something that's important is just the dynamics and the composite that they use to build wings today as they were 50 years ago is much different from, you know, the traditional zinc compared to the new composite. So that's, the airfoil over the wings is much
Right.
differently. That could, you know, is a big reason of why they're longer.
I think we've beat that runway to death. Can we stick with the building? Any other questions? Jen, would you like to make your presentation?
Well, I could make a couple of comments just to what was said, and then I will have Attorney Ziska,
Yes.
present. Just to speak to the hangar size, in my view, my opinion, if you have a variance from 1972 and the sizes of the planes and vehicles are smaller, and you need a bigger vehicle or plane now, I would think the appropriate route would be a new variance. So, just to speak to that. And just to speak to the municipal estoppel comment, where they're relying on town staff, Dan Precy, who didn't even work in our department for a year, gave the driveway permit. I spoke a couple of times with Mr. Jarmock and Mr. Attorney Donnelly before he started this project of the hangar. And I urged him that before you do anything, I suggest you at the very least come in and meet with us, say what you'd like to do, go to the zoning commission, talk to them, because what you're proposing is a much larger use than what's been there. So I just want to speak that I did direct them to, or urge them to come to us and come to the commissions prior to. I just want to kind of get those 2 statements out.
Thank you, Jen.
Good evening, board members. My name is Mike Ziska. I'm with the firm of Haller and Sage, here tonight representing the zoning enforcement officer, Jennifer Roy. For us, this is it's both a simpler issue and a more complicated issue than you've been presented. Oddly enough, I don't think that Mr. Jarmock and his attorneys and Ms. Roy are on different sides as much as you might think. What Ms. Roy just said, I think, is really key. There are 2 ways of going about what they're trying to do. And I think Ms. Roy's position, which we agree with, is that this is just the wrong way. And because it's the wrong way, if this board were to sustain this appeal, it could result in much more damage, much more harm than could happen if it was done in the correct way, which, as Ms. Roy indicated, would be to seek a modification of the variance. Now, it's not a question of whether or not this is a good idea. That's not what's before the board. I've had an opportunity to glance through which basically is a form letter that has been signed by a number of people. It wasn't written by them. Some of them don't even have the right addresses for themselves on the letter. So it's a form letter that was signed by a number of people. And most of it says, well, we support what they're trying to do. But that's not the question. The question is, did Ms. Roy make a mistake in denying this application? That's the only issue. And it's a procedural question as much as anything else. If you had an application to modify the variance, you would be able to establish conditions of approval. The biggest problem with what's happening right now is that this is being characterized as a simple non-conforming use, and that non-conforming use law is what the board should be considering in determining whether to grant this appeal or not. But it's not a matter of non-conforming use law. It's a matter of variance law, and that's a huge difference, which I'll go into in a little bit. So there are two other ways to go about it. One is to apply to modify the variance, in which case the board would have the ability to set conditions so that if the applicant says, we're only going to do this, we're only going to do that, the applicant can be held to those statements. They're correct in saying it can't be personal to the applicant, but that's part of the problem. That's what everybody assumed in 1972 when the applicant came in and said, this is personal to me, and his attorney said, this is going to be personal. It's only going to be limited to this applicant. They made those representations to the board, and your predecessors believed that at the time. At that time, if the variance had been challenged, a court could have found that the personal limitation, or any personal limitation, was invalid and struck it, but that would have taken the whole variance with it. As the applicant has said tonight, that law was changed. So now, despite what everybody was believing and relying on in 1972, some of those restrictions, personal restrictions, even if everybody was over the, on board in 1972, the board can't enforce them anymore. And by the way, it's since 1975, not since 1977. Also, Judge Berger's letter refers to it being an 11-year gap. It's a 3-year gap. But that's a different story. All right, so I assumed that Judge Berger's letter would be the heart of the applicant's position, and it turns out that that's the case. So I prepared a letter in response to that, which I have submitted to you. And so I want to go over that with you to the same extent that Attorney Donnelly read his into the record, because I think it's important for you to hear it from me tonight so you can ask questions if you have them. We've been asked to review Ms. Roy's May 31st, 2023 letter to Mr. Jarmuck explaining her reasons for denying the application to expand the hangar at 120 Watchog Road. 2, the administrative record of the variance granted in 1972. 3, the application materials. And 4, the opinion letter from Attorney Marshall Berger of Pullman and Comley dated August 4, 2023. Now, I want to say something about that. It's a custom among the legal profession to refer to retired judges as judge, even when they're no longer judges. The reason I am identifying him as Attorney Berger is in this case he's not acting as a judge. He's acting as an advocate. He hasn't heard both sides. He hasn't heard from Ms. Roy, or as he would if he were a judge. He's heard only from Mr. Jarmuck, and he prepared this opinion essentially for Mr. Jarmuck. So he's acting as an advocate as any attorney would do. And I think it's important to make that distinction. So, in preparing this letter, we have assumed that Attorney Berger's opinion will form the basis of the appellant's position before the board. Therefore, we will respond to the points made in that opinion in the same numerical order. 1, Ms. Roy's first reason for denial was that the current zoning regulations do not allow the proposed type of facility in the relevant zoning district. Attorney Berger's opinion asserts that she was incorrect because a variance was granted. That begs the question. However, as we will discuss below under point number 3, variances are designed to provide as limited a form of relief as is necessary to alleviate a hardship. Therefore, when the courts interpret the scope of a variance, they will generally confine them to the specific purposes and structures expressly requested by the applicant. In the present case, the variance application expressly requested a 70 by 40 foot hangar and expressly stated that it would be used only for the LaChance Potato Company. This was not conditions of approval. This is what the applicant was asking for. This is what the application said. since it did not authorize a larger building and since airport facilities are not otherwise allowed in the relevant zone, Ms. Roy correctly determined that the proposed new hangar was not permitted under the zoning regulations. Essentially, it's a question of what's the scope of the variance. If you're beyond the scope of the variance, it's not allowed. So number one is correct. It's not wrong. Just the fact that if a variance had been granted for them to build a 10 by 10 chicken coop, you couldn't say that building a big hangar was okay because there was a variance granted. You have to look at what the variance allowed. Number two, we agree that at the time the variance, I do need to depart one thing in the letter just to respond to something that was said. Attorney Donnelly said, well, it was actually a 70 by 50 building that was built. So we've already gone beyond the variance, but that's an enforcement question. It's pretty clear that back in 1972, the board was kind of supportive of what Mr. LaChance wanted to do. So I don't know whether anybody ever knew after the hangar was built that it was actually bigger than he applied for, but that's an enforcement question. If they didn't enforce the variance at that time, that's not a reason why the building should be expanded even further today. Two, we agree that at the time the variance was issued in 1972, state law did not require variances to be filed on the land records, although the pertinent statutory amendment was made in 1975, not 1977. As Attorney Berger's letter indicates. Three, this is the most important. Ms. Roy's letter of May 31st stated, quote, even if the variance was properly filed on the land records, the record of the variance application shows that the proposed building was to be no greater than 70 by 40 feet in size. Since the variance was based entirely on the proposed use, rather than on any dimensional considerations, the approval of the variance cannot be presumed to have allowed anything larger than a 70 by 40 foot accessory building. Consequently, the proposed utility building would be at best an unlawful expansion of a non-conforming use. End of quote. This is the key issue in the appeal. Now, Attorney Berger's letter challenges Ms. Roy's reason, but it cites two Supreme Court cases that are not factually or legally on point. The cases he cites did not involve a proposed increase in the size of a building allowed under a previous variance. Just didn't. Rather, they involved changes in the character of non-conforming uses that were not subject to variance restrictions. One was about how many helicopters flights could you add to an existing helipad. Had nothing to do with structures. The other one was how many antennas can you add to an existing radio tower. There's no increase in the structure. They added antennas. They added equipment in an existing building. And although Judge Berger's opinion doesn't say so, the building, the generator building, wasn't increased in size. They put the additional equipment inside the building. So the cases didn't involve a variance, and they didn't involve the expansion of a building, and yet those are the only cases he cites to you. A case that is far more compelling on the facts is L&G Associates, Inc. versus Zoning Board of Appeals, 40 Connecticut Appellate 784. And I actually have a copy of that case, which I'll give it to you right now. I only have one copy, but I'm just gonna read I have it for the record, but I'm gonna read the pertinent portion. I'm sorry, do I have it? No. The question in the case was whether a previous variance allowed the plaintiff to construct an office building. The trial court found that the variance did not allow the construction of the proposed building, and the plaintiff appealed to the Connecticut Appellate Court. That court upheld the trial court's decision holding that, quote, the scope of a variance is determined by examining the specific use proposed in the variance application and approved by the Zoning Board of Appeals. The court continued, because a variance affords relief from the literal enforcement of a zoning ordinance, it will be strictly construed to the minimum variance which is sufficient to relieve the hardship. I've got that section of the opinion shown in, highlighted in yellow, or highlighted in yellow in here. So you can read it for yourselves, but that's what it says. That's how you look at whether something is unlawfully expanding. What did the variance application say that the applicant was going to do. This applicant said he was going to build a 70 by 40 foot building, and he was going to use the facility only for the LaChance Potato Company. That's what he told the board. Okay. The Connecticut Supreme Court later cited the LNG case in Anatra versus Zoning Board of Appeals. Now, in Anatra, an application had been filed with the zoning enforcement officer to add a deck to a house that had previously been granted a variance to exceed a side yard setback requirement. So in other words, the applicant in Anatra had gone to the ZBA and said, I need to get a variance so I can go into the side yard a little bit. The neighbors came in, they were concerned about, well, you know, it's going to block our view. This is down in Essex, or Madison, rather. So they're worried about coastal views and things like that. And the board was very worried about how big is this thing going to be. So the board's application said, you know, whatever you file with us, that's what we're granting. So it put the applicant on specific notice there. If you give us plans, that's what we're approving. So that's what happened. They granted a variance based on a set of plans. The applicant comes in later, says, now I want to add a deck, and the deck is going to be entirely in the conforming area. So there's no zoning violation from the deck. Goes to the ZEO and says, give me a permit. ZEO says no, because the building you're approved for by the variance is limited to the footprint that you showed. So even though the deck would be conforming, because you got the variance, you can't add to it. The applicant challenged that. The Supreme Court upheld the zoning enforcement officer's decision. The Supreme Court, and going down to the bottom of page 2 of my letter, the Supreme Court agreed with the zoning enforcement officer, finding that the applicant was bound by the footprint of the house as it had been shown in the variance application. The court held that the terms of a variance, quote, should be construed not only by examining the language contained in the certificate of variance, but by considering the entire public record, including the variance application, the accompanying plans and exhibits, the minutes of hearing transcript, and the record of decision. And then the court continued, when the variance in the present case was approved, subject to the condition that the new house could not exceed the footprint of the prior non-conforming structure, the plaintiffs were required to accept the condition as a means of obtaining the board's approval of their plan. The plaintiffs did not appeal that condition. Accordingly, to the extent the proposed deck violated that condition, it was subject to approval by the board as a modification of the variance previously granted. Now, in this case, the 1972 application form showed a 70 by 40 foot hangar and an 80 by 2,500 foot runway. That's all the board and the neighbors understood to be at issue. And the hearing transcript makes clear that both board members and neighbors were concerned about the prospect of further expansion. Both the board and the neighbors were led to believe that the variance would be limited to the applicant at that time, something which state law actually does not allow. Two of the board members, and if you look at the transcript, you'll see this toward the end of the transcript, two of the board members expressly stated they'd vote for the variance if it was confined to the operations of the LaChance Potato Company, as the application stated it would be. So that's what everybody was relying on in 1972. It's going to be limited, going to be limited, going to be limited. Now, to the extent that non-conforming use principles might be tangentially relevant, the courts have always looked to the language of the relevant zoning regulations to determine whether and to what extent structures may be expanded. And I've cited a case called Moon versus the Zoning Board of Appeals, which held that zoning regulations did not allow vertical expansion of a non-conforming building in Madison. So you looked at the specific Madison regulations and said these regulations don't allow it. Now, I note that Judge Berger's letter doesn't even talk about summer zoning regulations, but Section 8.2.C.3 of the regulations provides, quote, any building or structure containing a non-conforming use which has been destroyed or damaged by fire, explosion, act of God, or by public enemy may be restored only to the same dimensions, gross square foot area, and cubic volume existing immediately prior to such damage or destruction. Likewise, Section 8.2.D.5 provides a legal non-conforming structure may be maintained, repaired, restored, rebuilt, replaced, or altered, provided such work, A, results in a building or structure with the same dimensions, gross square foot area, cubic volume, density, bulk, and site location existing in the previously existing structure. And it goes on from there. I won't quote that. But again, so even if this were just a non-conforming use case, you still couldn't do it because the regulations don't allow that kind of an expansion. They'd have to come to you for a variance. Therefore, the proposed building expansion is not only outside the scope of the variance, but it would also violate the non-conforming structure provisions of the zoning regulations. Now, Attorney Berger also suggests that expansions of non-conforming buildings should be reviewed in the same manner as expansions of non-conforming uses. In other words, whether the expansion changes the character of the use. That same argument was just made recently and rejected by another Superior Court judge in a case called High Watch Recovery Center versus Town of Kent Planning and Zoning Commission. To the best of our knowledge, there's no court in Connecticut that has ever used a character analysis to decide whether a building could be expanded. All of the cases dealing with building expansions in non-conforming use cases have said you can't do it. You can't expand. You need a variance to do that. Number 4, Ms. Roy's May 31st, 2023 letter stated, quote, "The variance application also expressly stated that the planes would only be used for the LaChance Potato Company. Although I understand that a zoning board of appeals cannot typically limit the benefits of a variance to any particular property owner," she acknowledged that, "this is a case in which the property owner himself chose to limit his application to use by a single company." Now, Attorney Berger's letter responds that under Connecticut law, variances run with the land and cannot be made personal to any property owner. And Attorney Donnelly said the same thing, that was her number 4, that this doesn't run with the land. She never said that. She never said that. She didn't say the variance doesn't run with the land. She says that the subsequent applicants may be entitled to nothing more than the original variance applicant was entitled to. And that variance applicant came in and said, I want this variance solely for the LaChance Potato Company. It's not a condition of approval by the ZBA. This has nothing to do with conditions of approval. And all of the talk about variances running with the land and so forth, and you know, you can't have personal conditions. There was no condition. It's not a condition situation. This is what Mr. LaChance asked for, and that's what he got. Just as the Supreme Court has said, what he asked for is what he got. You shouldn't go beyond that. So I know, that's a new issue. That's a tricky issue, and courts may disagree. I'll be the first to acknowledge that. But it's not the same as saying it's a personal condition. It's restricted to a single property owner. That's not what she said. She said that no property owner under this variance should be allowed to do anything more than Mr. LaChance said he was going to do. Okay, so there's a difference between deciding who has the right to conduct a use and deciding what the permitted use actually is. And that's going to be your job. Now, an analogous issue was decided, and I'm getting close to the end, so don't worry, I'm almost through. An analogous issue was decided in International Investors versus Town Planning and Zoning Commission. In that case, the plaintiff claimed that a zoning commission could not place time limits on a special permit because special permits run with the land. So he said you can't have a time limit because you got to be able to send the variance to the next applicant, and so if you have a time limit, it may not be able to get to the next applicant. But the appellate court and the Supreme Court both distinguished that situation. They said the same thing that I'm saying now. It's not the commission restricting or the board restricting the variance to a particular applicant. It's that any applicant or successor is stuck with the same conditions. Whatever the conditions of approval are, as long as they're not only this owner is entitled, everybody's stuck with them. And so the Supreme Court agreed that a zoning board, in a special permit case, it was a special permit case, I'm sorry, not a variance case, that the Supreme Court agreed that a time limit could be placed on a special permit. So they're distinguishing between conditions that are restrictive, but every owner has to comply with them, and conditions that say only this owner gets the benefit of them. That's not at issue here. And with regard to number 5, see number 4 above. So in summary, Ms. Roy correctly denied the application at issue because the variance granted in 1972 was simply not broad enough to allow the changes proposed by the current applicant. Just want to make sure. I need to say a few things about why this is so important. If this board decides that this appeal should be granted, what's it going to mean? Now, the applicants come in here today and told you, we're only going to have these particular planes. We're only going to be going, to these different places. We need to have a bigger building. That's all you've been told. If you grant this appeal, what's to stop the next applicant from coming in and saying, well, we need a bigger building, even bigger building. And we need to make far more trips than LaChance Potato Company was doing because that's our business. We're not a potato business, we're a different business. And we're entitled to use this runway too, for our business, just as they were entitled to use it for their business. So we should be able to have even more flights or do whatever. What's to stop somebody from coming in and doing that? So all of the representations that are being made to you, and I will note, in Judge Berger's letter, with regard to number 3, he cites all of this stuff that the applicant is going to do. How does he know that? Well, because the applicant told him that. So he's relying only on the applicant for what's going to happen there. But his opinion letter is saying, it really doesn't matter what was represented to the board, because there's a variance. So really anybody else can come in and do what they want to do. So that's what's the danger here. In contrast, somebody comes into you with an application to modify the variance, and you can say, we're going to hold you to these representations. You're saying that you're only going to use it for X, we're going to hold you to that. You're telling us that you have to have this building, we're going to hold you to that building for now. I'm not saying you would or would not modify the variance or approve the modification, but you could do that. And to be honest, and I will be honest with you, and this is where I said I don't think we're all that far apart. I think there are pretty good arguments that the applicant could make for modifying the variance. Some of the things they're saying in here aren't bad arguments for getting a modified variance. I mean, the airstrip is there. What are you going to do with the airstrip? So, I mean, that's an existing condition that has to be dealt with. And Ms. Roy's not harsh on that. I mean, she's never said the use of the airstrip is illegal. She issued an opinion, it's in the minutes here, or in the record, that said, yeah, what you're doing now is okay. So, it's not like the ZEO is out there waiting to attack somebody for using the airstrip. But on the other hand, we don't want this to be a situation where the variance that was issued in 1972 is being an open sesame. People can come in and do whatever. If they want to change what Mr. LaChance was asking for, they should have to come to you and ask for a modification of the variance. So that's one of our biggest concerns, that this will turn into an open sesame. The third thing that they could do, and I grant that this is much more difficult, but actually probably to be the best thing of all, would be to modify the regulations, the zoning regulations themselves, so that the Planning and Zoning Commission can decide how to restrict the use. It wouldn't have to come to you for a vote of 4-1 or, 5-0 or something like that. But that's more complicated. I understand that. So I doubt that would be the process, but that would at least be a lawful process. So for all of those reasons, and I do want to give you a copy of the Anatra case, where I highlighted some of the important areas. We can look at the whole case and see. So for all of those reasons, and again, with respect to Mr. Jarmark and what he wants to do, this is not attacking him or what he wants to do. This is just not the right way to do it. This application, this appeal should be denied. Thank you.
Any questions, board members?
Attorney Ziska, it strikes me that my understanding, my layman's understanding, although I've been on the ZBA for a while, is that our role in a case like this, where an order is being appealed, is a yea or nay, not a strategy of how maybe we could get this to a nicely well-tweaked variance. Am I wrong?
No, I think you're correct.
Okay.
I don't know of any way to say we're going to sustain the appeal subject to conditions, because either the order was wrong or it wasn't wrong. Now, what you could do is you could actually modify the order, I suppose. There's some law that suggests that you can modify an order, but that would usually relate to an enforcement order. So if the zoning enforcement officer said there's a violation here, I want you to do A, B, C, D, and E, there's some law to the effect that you could say, well, we're going to have them do A, B, and C, but not D and E.
That wouldn't apply to a denial.
Yeah, but this is you're right. I think this is a yes or no. Either the decision was correct or it wasn't correct. Thank you.
Any further comment from the public in the audience? Any questions, comments?
Can you keep the public comment portion open till the next hearing, so the public has a chance to obtain the documents?
That is my intention, Eva.
Thank you.
As long as the board agrees, which I think they will. Any other questions? My recommendation is that we continue until our September regular meeting. And I would like to get a motion to do...
Before you make a motion to do that, just I'll state on the record, that I do have a large number of letters that were hand-delivered tonight, 4 emails, and as someone dropped off an envelope today. They seem to be form letters, and I will have them available to the applicant and the public, but I will email them all to you guys to review.
I'll give you these exhibits, and if you can get anything you've gotten that we don't already have, and these exhibits, of course, the public can feel free to come to town hall.
There are 4 of them that are incorrect. The letter states that they live at 156 Watchog Road, but they live at other addresses. So, just for the record.
Okay.
I would make a motion to continue our hearing until our next meeting, which I presume is in September.
Can you put that on hold for just a second, please, Ralph?
Mr. Chairman, I'd just like to reserve my opportunity to respond to Attorney Ziska at the next meeting.
Yeah, it's still going to be a public hearing, so we'll hear all sides. We want to hear what everybody has to say. So we have a motion on the floor.
Second, Dan, there.
Discussion? All in favor? Aye. Opposed? Abstained? Motion passes unanimously. We continued.
Did you state the date?
The September regular meeting.
I think you probably should state the exact date and time.
September 12th.
Modify your motion.
Yeah, can you
So
modify?
I would modify it to continue the hearing until the September 12th meeting, the regular meeting.
At 7 o'clock.
Do you want to say 7 o'clock? Don't we still have a winery lurking out?
Yeah, no, we won't. Yep, no, we have a amended motion on the floor.
Okay.
Any discussion? All in favor? Aye. Opposed? Abstained? Motion passes unanimously. All right. Thank you, everybody. We have a motion to approve the minutes by Dan Thayer. Do I have a second?
I know, did you need a minute?
It would be the June 27th, 2023 meeting. That would have to be a special meeting, right? That was a special meeting. Why don't we table that for till the next meeting? Because, some people don't have the minutes, so. Do we need a motion for that?
I withdraw my motion.
Okay. Motion was withdrawn. We'll put the June 27th, 23 minutes on the agenda for the next meeting. Okay, do I have a motion to adjourn?
Make a motion.
Doug Stebbins, second.
Stand there.
All in favor? We adjourn at 8:40.
You know, what happened to this town where I want to put up a shed within 5 feet of my property line?
Shake things up a little.
Oh.